Hello everyone, today we'll deal with section 437 of the CrPC that deals with bail in non-bailable offences. So what are bailable and non-bailable offences is provided under section 2A, that is bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, whereas non-bailable offence means any other offence. So please hit the like button because we will be learning a lot today. So now let's start. Please refer to the Bail Act. So subsection 1 deals with, I have divided the subsection as such. Person is accused or suspected of committing a non-bailable offence. He is then arrested or detained without a warrant. By whom? By the officer in charge of the police station, or when he appears or is brought before the court. Appears also includes voluntary appearance, as I said in the earlier video, section 436. Is arrested by officer in charge or is appearing or brought before the court other than high court or the court of session, then he may be released on bail. Mark the word may, that is discretionary. So in non-bailable offences, granting of bail is discretionary. Also further it says, such person shall not be released if there appears reasonable grounds for believing that he has been guilty of an offence punishable with death or imprisonment for life. Here it is given shall, so it is mandatory. Here the words there appears reasonable grounds for believing do not obviously mean a mere suspicion or conjecture. The words mean such grounds as are based on reasons and logic and are not bereft of reasons. The grounds should be such as may lead one to believe that the accused is guilty of such an offence. Next clause, such person shall not be so released when if such offence is a cognizable one and he had been previously convicted of an offence punishable with death or imprisonment for life or 7 years or more. Also, he shall not be so released if he had been previously convicted on 2 or more occasions of a cognizable offence. Firstly, he had been previously convicted of an offence punishable with death, imprisonment for life or 7 years or more, and also previously convicted on 2 or more occasions of a cognizable offence. And such cognizable offence is punishable with imprisonment for 3 years or more, and when adding the 2 or more occasions, the total must be not less than 7 years. Let's learn through this again example. Suppose he has been previously convicted on 2 or more occasions, like he has been convicted of robbery, that is under section 392. He has been convicted for 5 years. Also he has been convicted of for attempt to murder under section 307, that is for 5 years, which is 3 years or more, and this is 2 occasions. So now let's add these 2 occasions, that is 5 plus 5, that is 10 years, which is not less than 7 years. So now let's see the 4 provisos given under this subsection. First is person referred in one clause, clause I, court may direct to release him on bail. There was given shall not be released. Here it is given may direct to release him on bail if such person is under the age of 16 years or is a woman or sick or infirm. Secondly, person referred to in clause 2, court may direct him to be released if satisfied that it's just and proper to do so or for any other special reason. Clause 2 says that he has been previously convicted, that's why he will not be granted bail. But here court may grant him bail if it appears just and proper to do so. Third proviso, mere fact that the accused person may be required for being identified by witnesses during the investigation shall not be a sufficient ground for refusing to grant bail. The fourth proviso, if the offence alleged is punishable with death or imprisonment for life or 7 years or more, and the person accused shall not be so released unless the public prosecutor has been given an opportunity of hearing. Unless the public prosecutor has been given the opportunity of hearing, the person shall not be released on bail, and the offence must be alleged must be punishable with death, imprisonment for life or 7 years or more. So subsection 1 deals with when court may grant bail. Here subsection 2 deals with when police or court, both, if it appears to such police officer or the court at any stage of investigation, inquiry or trial that there are no reasonable grounds for believing the accused has committed a non-bailable offence, but there are sufficient grounds for further inquiry, then the accused shall be released on bail, subject to the provisions of 446A and pending the inquiry. Is the mandatory part of the subsection that accused shall be released on bail subject to the provisions of section 446A and pending the inquiry. And also there is a discretionary part. At the discretion of court or officer, the accused may be granted bail on execution of bond without securities for his appearance hereinafter provided. So in this subsection, police also can grant bail in non-bailable offences. So now let's see subsection 4 of section 437 that deals with officer or the court. When they are releasing the person on bail under subsection 1 or 2, they shall record in writing the reasons or the special reasons under which they granted bail. Subsection 3 deals with where the person is accused or suspected of commission of the offence punishable with imprisonment which is extendable to 7 years, or an offence under chapter 6, 16, 17 of IPC, or the abatement of such offences, or the conspiracy or attempt of such offences, he can be released on bail. But the following conditions are to be imposed by the court. Those conditions are as follows. He shall attend in accordance with the conditions of the bond executed. He shall not commit any similar offence to the offence which he is accused or suspected of committing it. Also, he shall not be directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing or tamper evidence. Also, there are some factors which are to be considered by the court while granting the bail. Those are as follows. That is gravity of the offence, heinousness of the crime, possibility of absconding, nature of accusation, and as such. These were laid down in Jagdish Singh versus State. Please pause the video and note down the points. And it was also held that these grounds are only illustrative and not exhaustive. Subsection 5 deals with cancellation of bail. It says any court which has released a person on bail under subsection 1 or 2 may, that means cancellation of bail is a discretionary power, may, if considers necessary, direct him to be arrested or commit to the custody. While granting the bail, the court has to keep in mind not only the nature of accusations but the severity of the punishment. If the accusation entails a conviction and the nature of evidence in support of the accusations, reasonable apprehensions of the witnesses being tampered with also to be considered. Also, in considering whether to cancel the bail, the court has to consider the gravity and nature of the offence, the prima facie case against the accused, the position and standing of the accused if there are some. And this principle applies when the same court which granted the bail is approached for cancelling the bail. It will not apply when the order granting bail is appealed against before an appellate or revisional court. So now let's see some more points regarding cancellation of bail and others. When the bail is cancelled, it can be only cancelled by the court. Another court which granted bail can alone cancel it. If police has granted bail, it cannot be cancelled by the court or magistrate, but can be cancelled when by High Court or Court of Session under section 439. Also, where an order of bail is granted by a magistrate, it can be challenged under revision by High Court. This is a case decided, but there is some difference between application for cancellation of bail and revisional application. In the former, the order was valid when it was passed, but in supervening circumstances, it needs to be varied or modified or cancelled. Whereas in latter, that is revisional application, the order was bad from its very inception, from the very beginning. So later in Supreme Court decisions, the view came that order granting bail being an interlocutory order cannot be challenged under revisional jurisdiction. So no revision lies against order granting or cancelling bail. Subsection 6 deals with trial not concluded within 60 days. If a case is triable by a magistrate and the trial of the non-bailable offence is not concluded within 60 days from the first date of taking evidence in such case, then such person, provided the condition is that if he is in custody during the whole of the period, he shall be released on bail, unless for reasons to be recorded the magistrate otherwise directs. This provision has been enacted in order to avoid hardship to accused persons in non-bailable cases where the proceedings are prolonged unreasonably beyond a certain period, that is 60 days beyond. Now the last subsection 7, that is when the trial is concluded but before the delivery of the judgment, at any time before the judgment of delivery judgment and after the trial has been concluded, when the court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of any such offense, then the court shall release the accused if he is in custody by execution by him of bond without sureties for appearance to hear the judgment. So another important point, when a bail is granted or refused, there is no remedy available to the aggrieved person, no appeal or review. The aggrieved can go to the Supreme Court under Article 136 of the Constitution. So this is all about 437 section of CRPC. Hope you all will like it. Please like and subscribe the video.